last thing, can you see the screen right now?
Screen? Yes, I can see.
Okay.
Clear.
Okay, good. The PowerPoint is there, right? Okay, I'll start, and like I say, I'll speak for about 1.5 hours or maybe less, and then I'll take questions at the end, but I'm quite happy to take questions during the talk as well. So the outline of the topics that I'll be speaking on today basically follows a chapter in a book on law and technology in Singapore that some of us wrote 2 years ago during the COVID lockdown, right? It's a book that you can actually get. I think you can even get it free online sometimes on the Singapore Law Net. So you could write to the Singapore Law Net and see if they could give you copies free. But if not, I think some of the chapters for this book may be free on the Singapore Academy of Law website, right? So the topics I'll be talking about today would be shareholder rights and participation. It will follow what you might get in a normal company law textbook, right? So shareholder rights starts. Then we'll be talking about ways of communicating with shareholders to give them notices, for example, about meetings like the annual general meeting. Then I'll be talking about how these meetings themselves have become digital type meetings. And this was necessary, particularly because of COVID. A lot of companies, especially listed companies, could not hold their meetings anymore physically, and they had to move to digital and e-voting, right? Then after that, I'll go and look at capital in a company, how share certificates have now been dematerialized. They no longer exist in physical form. How these can be transferred using perhaps technology, right? And then from there, I'll move on to the capital structures in a company involving bonds, for example, debt that are issued by companies. I'll try and link these topics to the issue of information costs, because one of the central ideas in many areas of the law is that you either have firm, strict, mandatory rules in the sense that you cannot change those rules. We will see that company law may not be like that, and maybe it should not be like that. In other words, company law should be more contractual compared to being mandatory. But for that to work, you must be able to disclose these contractual terms to other parties, to third parties. So in many situations, we always talk about third parties. These are parties who are not part of an arrangement between contracting parties, right? And we will say that company law has many aspects of it which are contractual, but for that to work, you must be able to disclose those contractual arrangements and terms to third parties. Otherwise, third parties will not deal with you, right? And so information costs becomes a problem, and technology may be able to reduce that. Then we'll look at fundraising. Many of you would have heard of ICOs, tokens, coins, NFTs. We'll talk about that. And then finally, we'll end up with AI and decentralized autonomous organizations, which is the dream of certain people, that you could have companies and businesses running without much input from humans, and it can all be done by technology. You will see that I'm quite skeptical. I don't really believe in some of these things, but I'll try and provide a more balanced view, because I know that young people do believe in these things. So just a quick introduction. As I said, at my age now, some of us don't believe that things change that much. And so we think that technology is just new wine in old bottles. So things haven't really changed. It has changed only in terms of the language that is used, the names that are being called, are used sometimes, but it might just be that the underlying ideas and the law may not have changed, right? However, it may be that technology really will change the world. And because of that, we must be flexible enough to allow these changes to happen, right? So the argument here is that regulation must remain flexible and to accommodate changes. What does this mean? It means that when you draft laws, you must make sure that the laws can accommodate changes over time. It might be technology, it might be something else, but you have to try and draft your laws such that you don't have to keep changing it every time there's been a change in technology. So, company legislation, the words we say is that it should be facilitative rather than mandatory. It should be a series of rules that are not that different from contractual rules, as opposed to the kind of mandatory rules that you find, for example, in criminal law, where you cannot, even if the parties come together, agree not to follow those laws, right? So many of you would have come across some form of Companies Act in your countries. The argument here is that while there are certain provisions in the Companies Act that must be mandatory and might lead to, say, criminal offenses, other provisions in the Companies Act should be flexible, right? And that means that the Articles of Association should provide how the company actually works. So, for example, when you want to call a meeting, sometimes shareholders can try and call meetings. It might just be that in some countries, 10% of the shareholders can come together to do it. In other countries, 5% of the shareholders can come to do it. You may decide that this is a mandatory rule, but you can also decide that this is a facilitative, or what we call a default rule. Default in the sense that the Companies Act says it's 5 or 10%, but you can provide a different number in your Articles of Association, right? So for those things which are not so important that you must say that it's mandatory, we should try and allow it to be as facilitative as possible so that you don't have to keep changing the Companies Act when this comes about, right? But as I said earlier with information costs, this will only work if disclosure is operating well. And so we need to keep improving disclosure, right? Disclosure in the sense that parties can find out what the terms of the Articles of Association are, that parties have easy access to the Articles of Association. And so parties will know that when they deal with a company, there may be a few mandatory rules in the Companies Act, but there may be more of these flexible rules in the Articles of Association, but they can find out what those rules are. Without disclosure, you will find that you need more mandatory rules. This is because if you don't have disclosure or mandatory rules, dealing with companies becomes much less certain and the transaction costs will go up, right? So if your information costs go up because you need to find out more about companies and you can't find out about it, then you may not transact with the company. Or if you're going to transact with the company, you have to make sure that you get all sorts of guarantees, for example, from the shareholders, or some kind of indemnities that you expect to get from the parties before you deal with the company, right? So again, just to summarize this slide, we shouldn't have so many mandatory rules, but that means that there must be good disclosure. If you don't have disclosure, you must then have more mandatory rules again, because without either one of these two, it becomes very hard to trust the company and the business you're dealing with, and transaction costs will go up. Let's talk about shareholder participation and shareholder rights. I'm not sure whether this is the case in Indonesia, and I only found out today that Surakarta is actually quite near to Surabaya, which is where my father came from. I didn't know it was so close, right? I thought it was close, but not this close. I'm not sure shareholder primacy is the focus in Indonesia. I only guess this because I know much of your laws are still linked to Dutch law, and civilian law jurisdictions, even their corporate law, isn't the same as it is in the Anglo-American corporate law world, right? Where the focus is very much on shareholders and perhaps maximizing shareholder value. But still, I'm sure that in Indonesia, protecting shareholders is still important, right? So even in Singapore, even though we say shareholder primacy is important, coming from the other angle, this does not mean that it is only about maximizing shareholder value, because we have seen that this has caused problems around the world. What it means is that we have to provide a balanced way of giving shareholders enough value, right? It also does not mean that shareholders vote on business decisions, because the board is the one that votes on most business decisions. Shareholders only vote on certain business decisions, and very often they may not be actually making the decision, but they vote to confirm the decision of the board of directors, right? So the third bullet point says that directors still run the company, certainly in the Anglo-American model, but shareholders can replace them. So that's always the fallback position, that you can vote directors out with 50% of the vote, right? They can also vote on certain decisions like related party transactions, interested party transactions. They can also vote on large disposal of company assets, right? But again, they're not actually making the decision for the company. It is rather that they vote to approve the board's decisions, right? So shareholders do participate in the company, but they don't actually run the company directly. They actually have a fallback position in that they approve certain decisions, and they can also remove directors if they're not happy with them. But even if they don't run the company on a day-to-day basis, shareholders need to be kept informed of developments, right? They have to be kept informed of how the company is doing. Obviously, in publicly listed companies, this becomes very important. You have your annual financial statements. If you're a listed company, you probably have your half-yearly financial statements. I'm not sure on your Jakarta Stock Exchange whether you have quarterly reporting. I suspect you don't, because we in Singapore had quarterly reporting until we felt that this was too costly even for listed companies, and we've gone back to half-yearly reporting. Right? But even private companies needs to have an annual general meeting where they need to put their financial statements before the shareholders in general meeting, right? It could be very informal, because the meeting obviously in a private company is informal, but they must still be informed of the meeting. Right? So being kept informed of meetings is the foundation of shareholder democracy. But again, I want to stress that you have to be very careful with this, because shareholder democracy doesn't mean that shareholders run the company and that's all about shareholders only, because as we will see, there are many other constituencies in the company that increasingly we realize we have to worry about. There were always employees that we will have to worry about. And I think in Indonesia, for example, certainly your employment laws are more protective of employees than we are in Singapore, right? But today, we're also talking about protecting the environment, and companies may not have a direct duty to do that, but it's something that they have to take into account. So even in English and American law today, we say that shareholders are important, but they're not the only persons that are important, but we have to keep them informed about what is going on. So for this to happen, they must be kept up to date and informed of meetings, and perhaps be given other documents as well. In 2004, Singapore specifically introduced the electronic transmission of notices of meetings, right? But this was an example of perhaps how we were too early to do this without realizing that we should keep the drafting of the law in the Companies Act as flexible as possible. We drafted it in such a way that it looked as if the electronic transmission of notices of meetings could only happen in the way that it was said in the Act itself. And because of that, this has had to be updated a few times, right? As technology changes, as feedback is given as to how these electronic notices should be given, how it's received, as email improved, right? We have had to actually change the law in the Companies Act quite a few times, because the way it was drafted suggested that it was not possible to change the technology without changing the Act, because it was drafted like a mandatory rule. And again, some of us have been writing about this for many years, but in Singapore, many of our lawyers believe that the Companies Act is mandatory. But I want to stress once more that the Companies Act is not like the criminal acts or the penal code where everything is mandatory. Many things in the Companies Act should be facilitated. And in the most recent set of amendments, the Singapore Ministry of Finance has agreed, and this was in 2018. It has said that the rules should be less restrictive and less prescriptive. So it should not restrict how you do it, nor should it say that you must only do it this way, right? So the way it has now been drafted is that electronic notices need to follow the Act only if the company's constitution has not been appropriately amended. So the constitution is our Articles of Association. And I said earlier, the Articles of Association actually provide the details of how companies should be run. But previously, it was drafted in such a way that it appeared as if your constitution could not be different from the provisions in the Act on how electronic notices were communicated. But in the latest round of amendments, they have made it clear that electronic notices can follow the corporate constitution and does not actually have to follow the way the Act suggests it is. The way this has been done in the Act is that you put a provision there which says subject to the corporate constitution or subject to the Articles of Association. Now, I'm not sure that you need to do that because in other countries, in the US and in the UK, it is usually the case that if it's silent and the Act does not say that this is mandatory, you can, in your Articles of Association, depart from the Act. But Singapore, I suspect Indonesia is the same as well, being a more traditional law type economy, and most people follow the rules more strictly. Unless the Act says you can depart from the Act, most of us will follow the Act, right? And that's how it is with lawyers in Singapore as well. And so because of that, I think the Ministry of Finance felt it was necessary to put a clause in to say that the corporate constitution can depart from the Act. And so therefore, this is what we call a default rule, but it becomes an express default rule, whereas in other countries, it might just be that you don't have to expressly say it's a default rule. But again, for it to be a default rule and for disclosure to work, it means that there must be easy access to the Articles of Association, right? And also that your practitioners amend them to keep up with changes. Because we could say that we want to have default rules and to have flexibility, but that won't work if people can't access those rules. And it also won't work if your practitioners are perhaps too lazy to amend them to keep up with changes, right? And as I said earlier, this is why many practitioners in Singapore still see the Companies Act more as a series of mandatory rules. Because if the flexibility is given, they will have to then amend the constitution more often, right? So like in Indonesia, I'm sure you have a model Article of Association or model constitution, which you adopt when you incorporate a company, right? But that means that you have to keep changing this constitution if you want to amend how the company is run, right? If you want to, for example, change how your meetings are run, shareholder meetings, and certainly board meetings, because board meetings, you don't find details in the Companies Act, you only find the details in the Constitution, right? But if the practitioners are not that, up to date, they may not amend these things. And then you have to rely on the government again to amend the Act. But if this happens, you will always be behind changes in technology, right? So what we have done is to have put something in between, which is that you have a choice to adopt the model constitution at the point of incorporation or have the version that may be enforced from time to time. What this means is that when you incorporate your company, you have a constitution that you've taken from your authorities, and you don't have to amend it to keep up with things. You're still now relying on your company regulators to amend the constitution. And once they amend the constitution, your own constitution keeps up with the amended constitution. Now, this is a good idea, and it has been tested in some other jurisdictions, but it may not be that easy to work if the company's constitution is not somehow linked to the model constitution in the regulators have come up with. And so it requires some kind of technological linkage, hyperlinks, and so on. And I'm not sure many of us have been sophisticated enough at the moment to hyperlink the constitution of a company to the model constitution provided by the government. And so in Singapore, even though we have this, very few have used this, what we call automatically up-to-date constitution that follows the model constitution as it's amended by the government. So in the end, what we have in Singapore is still one situation where the government still usually has to amend the act, but that has to go through Parliament. It takes a long time. If they could have amended the constitution, that's very quick, right? The regulators do it without having to go through Parliament at all. And it's only a model constitution anyway, so it's just contractual. But we don't seem to use that. So what we have is a system where a lot of provisions in the act are still seen as mandatory. There is the constitution, but every time you want to change the details of the constitution, the company and its lawyers will have to amend the constitution, right? So the fundamental question here is whether you think company law is state or practice driven. I think in Indonesia, and certainly it still is in Singapore, it is still quite state driven. There is some practice element in it, but not as strong as it is in Western countries. But it would be ideal if both could work together in a better way. Because practitioners are at the front line, right? They know what's going on, and they can better come up with changes than the government. The state always lags or is behind the technological curve. And it's the same with meetings. Here we're talking about digital meetings. So the Act suggests, this is the Singapore Companies Act, and I'm sure it's the same in Indonesia. It suggests physical meetings and voting, right? That the meeting must be held in person and that there may have to be a vote taken. It is true that sometimes the Act allows meetings or decisions by circulation, but that means that you still have to circulate it amongst all the shareholders, and it only works in a small company. So as the company gets larger and larger, physical meetings need to be held. And this became a problem with COVID-19, right? Because we couldn't hold our annual general meetings, nor could we hold any extraordinary or emergency general meetings that you needed. And because of that, voting couldn't be done, right? So we needed to pass emergency legislation, and the Ministry of Law passed these very quickly. I don't know whether it's the same in Indonesia, but I suspect it's the same, right? Because our act isn't flexible enough and wasn't drafted flexibly enough to allow for these meetings to go ahead. All these emergency legislation, however, is going to end in Singapore in July 2023. And so now the act has to be changed. And so we have now seen the various drafts, amendments that will come into force, I think, very soon to allow for virtual meetings and voting going into the future, right? So we've had the emergency legislation for 3 years now, but they're going to expire. But now we have to actually change the act. But I still believe that we should provide for more flexibility, because we're going to have problems if we draft it too narrowly and if we don't allow the constitution to be flexible and provide more details, right? Because no matter how well you draft an act, things are going to change, right? So for example, how should questions be asked at the meeting? Even if we are thinking now of drafting something for the act to take into account electronic meetings and virtual meetings and voting, how is it going to be carried out, right? There's going to be questions. Are you going to allow questions, right? Or will the chairman just, take questions that, for example, here on this online thing, you have to write in the question using the I think there's a chat function here, right, on Zoom. Is that how it's going to be done? Or can you interrupt, which I'm quite happy for you to do, and ask a question, as I told Arief from the start, right? If we're going to have e-voting, let's just say that this Zoom call has a facility for you to vote, right, on something I'm saying. How secure is it? Because someone could hack into that and change your votes or confuse us by voting when they're not actually part of this meeting as well, right? So all those things will have to be thought of and future-proofed, if that's the right word, right? So I think we still need to build in flexibility where we can. Now, it is true that blockchain technology has helped with voting at the board level for sure. It provides some security there, but that's at the board level, and boards are very small, right? You have maybe 5, at most 12 board members, and they are all people who know each other. So that's fine. You can use technology to do board voting, right? But shareholder meetings can be very, very large, and many shareholders don't know each other, right? So how do we make sure that the right shareholder is voting? Because, some of you are on screen, I can see Arief, but a lot of you are not on screen. Are you the one voting, or someone hacked into your account and is actually voting for you? So all these things have to be driven by practice. And the example here I gave of the flexibility of English laws, which I think is one of the more flexible companies acts in the world, is that the first UK live presentation teleconference at a general meeting was actually in 2016, long before COVID, right? And this was in Jimmy Choo's UK AGM. Some of you will know, I think Jimmy Choo was a Malaysian who makes very expensive shoes now that none of us in Southeast Asia can afford anymore. But he's been very successful. And I think he or she, I'm not sure who Jimmy Choo is, wanted to portray a very modern, young sort of approach, not just to the designing of shoes, but also to how the company is managed, right? So they managed to do all this without the Companies Act helping, right? Because it was flexible enough. And all you have to do is make sure that your corporate constitution, the Articles of Association, allows this to happen, right? So this happened, in June of 2016. So it's almost exactly 7 years ago now. So just coming back to the story, where we can, we should build in flexibility so that our laws don't become outdated or obsolete very quickly. One area that we have actually also experienced technology very early on already, right? So with meetings, I think 2016 was Jimmy Choo as early as we saw it. But with share certificates, we actually experienced technological changes 30 years ago already, right? Because we saw shares becoming scriptless. That's the word that we use in Singapore, scriptless. It just means that the shares did not have a physical form anymore, right? I think in Indonesia, you'll be talking about things like the dematerialization of shares and bonds, so that when you transfer it, you don't need to have a share certificate, right? You don't need to have a share transfer form, sign all these things together and send it back to the company. But transfers can happen just by crediting or debiting an account on a secure system, right? And so in Singapore, in 1993, even the shares that are listed on the Singapore Stock Exchange went scriptless. They were not truly dematerialized because actually the share still existed, but there was only one share. So every listed company, and we have about 650 listed companies, every one of them would have just one share certificate with the hundreds of millions of shares, and this is left with the Singapore Stock Exchange. The Singapore Stock Exchange then has a depository called the CDP, which is this last thing on the last slide here, the last bullet point here, CDP, which creates accounts for those of us who are shareholders in these companies.
Yeah.
So that happened 30 years ago already. And so some of us who are more skeptical of blockchain says that, well, you don't actually need modern blockchain because you can have a blockchain that is a secure system that is used internally between members of that system. And that is what we've had for 30 years already, right? So this is what's happened with listed companies. Some of us believe that increasingly it will also happen with private companies, right? How we record share interests right now with private companies is that a company keeps a register and you still need to have it registered with the company. But it might just be that you might have modern blockchain systems that will allow private company shares to be maintained and the register kept with this blockchain system, right? So so the company may not have to maintain the register anymore, but you'll have a blockchain system that records these interests, even in private companies, and allows for the transfers of interests in shares in these private companies, right? What will happen is exactly how it's been happening for 30 years with our listed companies. It just requires the debiting and crediting of those of us who have shares in, say, I'm not sure whether Asia Food and Paper, right? AFP, which is an Indonesian company that was listed in Singapore, I think. I'm not sure whether that is still listed, but if you were to buy shares in AFP in Singapore, the seller will have shares debited from his or her account, and the buyer will have shares credited from his or her account, right? And this can happen easily because for publicly listed companies, the directors have no discretion to refuse to transfer shares, unlike with private companies, right? So it has been done for 30 years now. The CDP, the Central Depository, simply debits and credits account when people buy and sell shares. Now, people have said, why can't we do the same thing with private companies? And the technology people in particular are always accusing the law people of not knowing things, right? But that's because the technology people don't understand that with private companies, there's always a discretion given to directors to refuse to transfer the shares. And so therefore, it's not so easy to transfer shares in private companies. Even if you use a blockchain, it may not happen automatically because the directors have this discretion to refuse to transfer. And once you have that, it actually defeats the use of the blockchain technology because it will not happen smoothly. Directors still have this discretion, and you might as well ask them to decide whether to transfer by handing the share certificate back to them, right? It might take just as long. We're not sure at this moment we can remove this discretion because in private companies, especially as the company is very small and it started out as a partnership, all the shareholders there trust each other, and you may not want them to transfer their shares to outsiders, right? You may have things like preemption rights, where rights must be given to the existing shareholders to buy out the other shareholder first before you can transfer it to outside parties. So these things make it difficult to use blockchain technology to make transfers in private companies that easy. The other thing we have seen that may make it difficult with private companies is that in the case of publicly listed companies, many people who buy shares on our stock markets may not actually provide all the financing themselves, right? So let's say I want to buy AFP shares on the Singapore Stock Exchange. I may only have 50% of the money required, right? And the other 50% is provided by the stockbroker, right? And when that happens, usually the shares will be kept in the stockbroker's name, right? And so they are an intermediary that provides financing, and they act as my nominee, right? So if you look at the CDP, the name of the account holder will be the stockbroker, right? Not me. My name will only appear on the books of the stockbroker, right? So a lot of sub-accounts, in other words, are being used in these situations. That, again, may or may not happen with private companies, and that complicates matters, right? I just want to show you this diagram, which I took from a Taiwanese professor, Zhang Chunmin. It's quite a good diagram to show you how more complicated share registers are today, especially with publicly listed companies, because many of us may not maintain an account directly with the central depository, right? So you have an issuer here, right? In the old days, they would have, again, like I say, printed paper, share certificates, and you and I, those of us who are investors here, will hold share certificates that belong to, say, AFP, right? But today, that's not what happens. What actually happens is that AFP may have someone who manages their accounts for them. This could be, as I say, the central depository in Singapore, right? And so if you look at the books of AFP, who is the shareholder? There's only one shareholder, and that's the central depository here, right? KSD. Oh, sorry, he was Korean, so this is a Korean securities depository that I was talking about, right? But it's more complicated because some of us, so let's talk about maybe not AFP, but the Korean stock market. And this is Samsung, right? The shares are now immobilized here, or they may not even exist physically anymore. And the Korean Securities Depository is the one that seems to own all Samsung shares, right? But of course, that's not true, because they are just holding shares on behalf of those of us who are shareholders. But unfortunately, because this is in Korea, very hard for us to buy shares directly in Korea. We use a stockbroker. Some of you will be using it from Jakarta. We were using out of Singapore, right? This could be a stockbroker that's an international stockbroker, like say Merrill Lynch. Merrill Lynch has an office in Singapore. It's also got an office in Seoul. And so we buy shares through Merrill Lynch, and Merrill Lynch provides financing for us, right? We only provide 50% of the cash up front for Samsung shares, and Merrill Lynch provides the rest. Because of that, Merrill Lynch wants its name to appear on the Korean Securities Depository name. And it looks as if Merrill Lynch is now the shareholder of Samsung, right? But the reality, of course, is that we are the shareholders because we have provided the thing. And all Merrill Lynch has done is made us a loan. And we are actually the owners of the shares, the ultimate owners of the shares, right? Merrill Lynch has taken some kind of interest, but it's not a direct ownership interest. It could be a charge, a mortgage interest, right? But it appears in their name. So what happens is that our rights are only seen on the books of Merrill Lynch, right? Whose rights are also seen on the books of the Korean Securities Depository, whose rights are seen on the books of Samsung, right? These are how things work now in modern stock markets and in modern depositories. And that creates problems for things like choice of law for the transfers of securities. Because, so say those of you in Surakarta or in Indonesia right now are investors and you're buying shares from me. I'm in Singapore, right? And we are all the ultimate investors down here. If you can see my cursor, right? We may think that either Indonesian law or Singapore law applies to this, right? But actually it may depend on the law of this intermediary that we are using, right? So are we both using Merrill Lynch in Jakarta or are we using Merrill Lynch in Singapore to do this, right? But it may also depend on the laws of Korea because the ultimate transfers, in a sense, will have to be indirectly recognized all the way up here. The law as it stands right now is we are just trying to keep the recognized choice of law at the level down here with the intermediary. So it's either Jakarta law or Singapore law that governs this, because otherwise it'll become very uncertain whether the transfers between yourselves in Indonesia and me in Singapore will have to worry about Korean law as well. So this is how things work. We have indirect rights now. That's the word that's used here. In the old days, we had direct rights and we exercised those direct rights. Today, we can only exercise indirect rights. And so we have to make sure that those indirect rights are protected as much as possible. Further things to talk about with respect to shares. For private companies now, so we're not talking about public companies. For public companies, you have all these depository registers. I'm sure Jakarta has one, just like Korea has one, just like Singapore has one, right? But for private companies now, due to concerns with money laundering and from the Financial Action Task Force, and they want to know who are the controlling beneficial owners of even private companies are, there needs to be a register for this, right? And so in Singapore, already the registrar of companies, in effect, keeps a register of shareholders, right? So moving towards a system for private companies that uses the blockchain may not be that far away, because we already have increasingly some kind of public register that keeps account of these transfers and ownership in private companies, right? But as I said earlier, share transfers through private blockchain of private companies will be difficult, because the directors can still refuse the transfers, and there may be restrictions on the share transfers. What this shows is that it is going to be a difficult issue to think about. And it also shows that transfers of shares are not simple passing of property. I think many of you would have studied property law. When we transfer property, we simply think of delivering it, right? The share certificate in the case of a publicly listed company like AFP is like that, right? We just think of ourselves selling it, you guys in Indonesia selling it to me in Singapore. But that's probably not actually legally what's going on, because strictly the transfer of a share requires the company's consent in a way, right? And this is more like a novation of the relationship between the shareholders and the company, right? So what I'm saying here is that if we look at the share certificate in the old days, or think of your share in AFP, you think of it as a transfer of shares. But when you think of your share certificate in a private company, even if we move into a blockchain form of transfer system, it is not that easy, right? Because it requires the director's consent. And therefore, this is more like a novation, which those of you remember from contract law is the changing of the contracting parties in a contractual relationship, right? And this means that it is a more complicated process. What I believe is that technology can resolve the problem by allowing the transfer to be conditional, right? So the transfers of shares in a private company may not be immediate. It's a conditional transfer, right? But at the same time, you also must give notice of those share transfer restrictions to a person who's buying shares in a private company, right? So you have to resolve these issues. Technology can help, but I think that it is not that simple a process, that the law needs to also become quite sophisticated in recognizing that the transfer is only conditional. And also there must be a way of giving notice of those restrictions, so that if I buy a share and I have notice of those restrictions, I may have to accept those restrictions, right? It becomes something like the things that you have in property transfers. I've been talking about shareholders. We always forget that companies are not just there for shareholders, but we also have creditors, and even more importantly, employees. In Anglo-American world, we don't worry about employees that much, but I think in Indonesia and civilian countries, you do worry about employees. But here I'm talking about bondholders. Bondholders are given some kind of protection, but they're not given as much protection as with shareholders. And we have seen this problem most recently. I don't know if any of you were following what was going on in the AT1 bonds with Credit Suisse, right? Where the bondholders there were wiped out, even though equity was not wiped out. So normally bondholders rank above shareholders, right? But in the AT1 Credit Suisse bonds, they ended up ranking below shareholders, right? When Credit Suisse shares were transferred to Union Bank of Switzerland. So we do need to protect bondholders, but they're not protected that much. There is a register that is maintained by the company in Singapore, but this cannot be assessed by the public, right? And the problem with not being able to assess it is that the bondholders don't know who the bondholders are, each of the bondholders are. The shareholders can find out who are the other shareholders, right? But bondholders find it very hard to find out who the other bondholders are. And so when companies became got into financial difficulty, and they needed to restructure the bonds, there was serious collective action problems, right? And so the bondholders, did not know and whether to vote to accept these changes in the terms. There's much less statutory regulation, and what we call collective action problem starts because they cannot cooperate as well as shareholders can. So despite Singapore's new restructuring rules, few companies have been successfully restructured. I believe this is where blockchain registers can help, because bondholders can all voluntarily inform the blockchain register that they are bondholders, and then somebody can come together and contact all of them and probably improve the cooperation amongst bondholders, right? But I think this one will be privately driven, right? With the private shares, I think that will be driven partly by the government, because already there is this register to control beneficial ownership. But with bondholders, because cases have said that creditors are expected to protect themselves, you find that I think a blockchain register of bondholders will have to be privately driven, right? But I think it will also be part of the need to have a company's real-time balance sheet. Let me see whether So you know that a company has both a balance sheet which captures the existing state of the assets and liabilities, but that only comes and you see it at the end of the year, the financial year, right? And in the case of listed companies, maybe half yearly, they will draw up a state of the company. But you could be dealing with the company in September, October, midway through the year, and you're not sure of the balance sheet, right? Because the company could have been, what you saw 6 months ago in terms of its balance sheet may not be accurate now. So the balance sheet does not capture the state of company, and it would be great if you could have a real-time balance sheet instead of only the one that you see at the end of the year, where the directors have to certify that they are true and fair, right? As I said, it is easier to monitor listed companies and they report half yearly, or in some countries quarterly. But many things happen during the year which may be difficult to know or to follow, right? And so it may be useful to have this real-time balance sheet. One example that we have in Singapore now that may require a real-time balance sheet is that share capital can be increased without the issue of new shares. So this is not a loan that an existing shareholder makes, but a shareholder wants to increase the share capital, but it doesn't want to take new shares. So the company is not issuing any more shares to this shareholder, right? But the capital line in the accounts of the company has been increased. But there is no way to capture this because the register of companies will not look at this until the end of the year. If you have a real-time balance sheet, it could capture the fact that actually now the company has more capital in it, right? At the moment, we don't have this, and therefore we have not been able to capture this. And so when shareholders want to put more money into a company, they are a bit worried that people will not know that the share capital has been increased, or third parties who deal with the company will not know it. And so very often they may inject it as a loan rather than increasing share capital, right? Because if a loan, they become a creditor, there's a contractual document and they feel protected that way. Whereas when the share capital goes up, they don't get new shares. They feel that there's no way of representing the fact that they actually have a larger part of the share capital now. All this shows that company law is flexible, because even though the Act only refers to raising capital by issuing new shares, what the courts in England have said is that there's no reason why they cannot increase share capital without issuing new shares. Right, let me carry on. I'm getting some feedback because I think some of you are not may not have muted your microphone. Yeah. Right. So let's go on and talk about capital structures, right? I took if you feel you need a short break, Arief, you can tell me as well, but I'm quite happy to go on until 11:30, and then we'll have questions then. So let's talk about capital structures in general now. So I was talking about the balance sheet, right? But capital actually appears on the right side of your balance sheet. So you know your balance sheet will have some things where you have the left, right side. But it used to be that capital was maintained quite strictly, the rules, so that when shareholders put money into the company, it wasn't easy for them to take their money back, right? Except through dividend payments. But many parts of the world, they have been weakened. And so now we see a lot of share buybacks. We see capital reduction, right? And that so long as this company is solvent, they can do these things, right? What then is required is a solvency statement signed by the directors. So if the directors sign a statement that the company is solvent, then they can do a share buyback or capital reduction. However, what we have seen in Singapore, and it might just be the same in Indonesia as well, is that directors may be reluctant to provide this solvency statement as they could be liable for this, right? It used to be stricter in Singapore because they had to do a statutory declaration that the company was solvent. But the directors themselves are not that sure of the state of the company, right? Because the balance sheet is done every year or every 6 months only. So again, a real-time balance sheet may help here, right? As insolvency is both dependent on a cash flow test as well as a balance sheet test. I'm not sure the position in Indonesia, but in Singapore, as well as in the Anglo-American world, insolvency is increasingly now a cash flow test, right? That they cannot pay their debts as they fall due. It used to be that balance sheet was just as important. And as I said, balance sheet is harder to show, right? Because the cash flow test is one where so long as the company can meet its debts as they fall due, nobody is unhappy that they have not been able to pay their debts, then nobody puts the company into bankruptcy. But if you need to monitor the balance sheet, then you have to find out whether the assets are in fact still greater than the liabilities, and that's harder to do, right? And so it might just be because of this difficulty that the courts have started moving more to a cash flow test. But having said that, they cannot totally ignore the balance sheet, right? Because if the company is hopelessly insolvent and it's only paying its debts now because it's borrowing money from other people, then that is no different from a Ponzi scheme. You've heard of this word, where a Ponzi scheme is one where your initial investors get their money back because you can only borrow money from the later investors and you have to keep going on like this, right? So a balance sheet test is still important, not as important as the cash flow test, but because of its importance, maybe we will need this real-time balance sheet, and technology may help, right? Another reason why we may need this is because even if the company is not insolvent, many countries have a rule that you cannot transfer corporate assets to a third party in a way which prejudices creditors of the company. So in Singapore and in the UK, we have a law that says that you cannot transfer assets if this will hinder or delay or prejudice creditors and the repayment of creditors, right? Because what you're doing is defrauding creditors. So again, because of this, it might help to have some kind of real-time balance sheet, because if the company is very, very rich, obviously you can transfer this, there's no problem. But if the company is not in good shape, even if it's not insolvent, you should not be transferring assets out if this could prejudice creditors. There was an important UK Supreme Court decision on this in a case called BTI versus Sequana. This had to do with environmental damage. A company was set up as a subsidiary to pay for environmental damage by the group. And this damage was going to be over many, many years later on. But before they had to pay, the subsidiary went and gave a large dividend payment to the holding company, right? So what happened here again was that a subsidiary was set up, and this subsidiary was set up to cover all the possible environmental damage claims over the next 20 years. But before those claims had become real, they made a dividend payment back to the holding company, right? So this was seen as a transaction defrauding creditors. And so it had to be repaid. And this had nothing to do with insolvency because the subsidiary only became insolvent 10 years later. So as I said, this is not an insolvency rule. This is a rule that protects creditors. However, by the time it came to court and the holding company was asked to repay the dividend, because it was the only major shareholder and was asked to give back the dividend, it could not do so, right? Because it was also insolvent, right? So the money had been paid by the subsidiary to the holding company, and now both of them were insolvent. So what happened is that the directors of the subsidiary were now sued for breach of their duty to act in the best interest of the subsidiary company. They were found not liable as insolvency was not imminent or probable at the time the dividend was paid. So this is an example of how shareholder primacy in England still was more important than taking into account the interests of creditors, even though the interests of creditors had to be taken into account when a company is insolvent, right? But it has to be imminent or probable because before this duty to creditors arose, and the directors were not liable. They did not breach their duty to act in the best interest of the company because the best interest of the company is largely still the interest of the shareholders. So this was a very controversial decision that took a long time for the UK Supreme Court to decide because there was a clear breach of the rule that said that this payment would delay, hinder, or defraud creditors, right? But unfortunately, as we've seen, the holding company could not repay the money, and the directors were lucky because somehow the duties of directors was not linked to this separate non-insolvency rule, not to defraud creditors. Instead, it was only linked to this general duty to act in the best interest of the company, which only had to take into account creditor interests when the company was insolvent, right? So a real-time balance sheet might have helped because the creditors may have been able to find out that they were going to be prejudiced at an earlier stage, as opposed to only at the later stage when the company in fact became insolvent, by which time all the money was gone and they had to sue the directors. And as it turned out, the directors were seen not to have breached their duty. But this story with real-time balance sheet is about information costs. We need to reduce information costs as much as possible, right? To protect third parties. The creditors in the Sequana case, if they had found out earlier, they could have brought the action earlier, and maybe they could have recovered something from the holding company. The problem with companies is that much of what the company does is through human agents, right? They can't do it themselves, and they have to do it through human agents. And you have to trust human agents in a way because that facilitates transactions, right? The company is always an artificial entity. You cannot always ask the entire board to carry out every act because that becomes very expensive. The entire board has to decide on everything. So you hire employees and you hire individual agents as well, right? That lowers transaction costs. So that makes using companies cheaper, right? However, once you use agents, that creates what we call agency costs, right? You have to make sure that the agent doesn't cheat you. At the same time, it also increases information costs to third parties because these third parties need to know whether the agent had the authority to carry out those actions or not, right? So again, the whole idea of using agents is about costs, right? It decreases transaction costs for the company, but increases agency costs because they have to monitor the agents. And also increases information costs for third parties. So there's a balancing exercise that goes on here that can be helped with more disclosure, right? If things could be better disclosed, we will find that you can both reduce agency costs by having a law that protects the company most of the time, but at the same time, that won't impose too much information costs on third parties because they can find out exactly what the arrangement between the company and its agents are. Many of you would have learned about doctrines like what is the actual authority that is given to the agent. In some countries, I know not in China, I'm not sure how it is in Indonesia, it might also be that the agent have what we call apparent authority. They appear as if they have the authority to do certain things. But that one we have to be very careful about because it could be that the agent is cheating both the company as well as the third party by pretending to have the authority, right? And so in those situations, it will create a loss, and that loss will have to be suffered by either the company or by the third party. Very often today, that loss is borne by the third party because the company would have limited the authority of the agent, right? And it's the agent who's the wrongdoer, but the third party did not find out enough when they entered into the transaction with the agent. And the law as it stands now seems to protect the company more than the third party. What we can do to protect the third party in these situations is to create perhaps more corporate information through blockchain registers so that third parties can find out about the company's internal arrangements with its agents. I've got another half an hour, so I think I better move on. I'll move to a different topic now, which I think a lot of you will be more interested in because we're no longer talking about company law. We're moving into securities regulation in a way, right? So in the past, companies raised finance through shares and bonds, right? Today, of course, they also do so. Many companies do that, right? They issue shares and they issue bonds like APP and AFP did. Once a company gets larger, there will be an IPO, an initial public offering, or a listing on a stock exchange, right? Where prospectus disclosure is required. So now from a small document, you have a very, very thick document, the prospectus, right? Which 40 years ago, the longest was 25 pages. Today, on average, there are 250 pages. So it's a lot longer now, the prospectus. Underwriters would be involved. What it means is that you have a bank that comes in to make sure that the process is okay, that there is no wrong disclosure. And the underwriter may, in fact, buy the shares if the public doesn't want to take up the shares, right? So they have to themselves subscribe for these shares. However, this can be a very costly process, and so many small businesses may not do an IPO. Increasingly, small companies may use alternative financial instruments like coins or tokens. This may not be seen as a share or debt, and for quite a while, Singapore was very liberal and very willing to allow people to issue coins or tokens without a prospectus because this was not seen as an issue of a share or debt, right? So no prospectus required, right? Now, this happened in the last 4 or 5 years. Prior to that, there was already equity or debt crowdfunding, right? Where there were shares or debt issued by crowdfunders, people who raised money through crowdfunding. This also didn't require a prospectus, but that was different. That was where a prospectus was required on the face of it, but because the sums raised were so low, less than $5 million in Singapore, no prospectus was required, right? So those SMEs that did crowdfunding using equity or debt crowdfunding managed to avoid a prospectus because they raised small sums of money. Today, it might be different. These coins may be more than $5 million, but no prospectus is required because it's not seen as a share or debt. I'm only describing to you what's happening, but I'm not saying I agree with this because I think that coins and tokens could be seen as shares or debts, right? But the main thing is that there is no outside underwriters when you have no prospectus to ensure the accuracy of any information that is given. And so it's much riskier when you buy coins or tokens as opposed to buying shares and debts from companies that are listed. Again, this is with crowdfunding and any small offering. It is not an issue. You don't need a prospectus anyway if the sums raised are low, right? And that's fine because every regulator wants to help small and medium-sized enterprises, SMEs, as SMEs employ the most people in the world, even though their share of corporate profit is actually very low compared to large companies. So it means that they actually pay out a lot of their revenue in terms of salaries compared to larger companies. So we want to help SMEs. The problem is that they cannot raise finance directly with investors very easily. So even though we have this small offering exemption for crowdfunders, and even for coins, if you want to do it as an SME, you can do it less than $5 million, which is enough for an SME. The problem for them is that they cannot reach investors. How will they go about getting investors to put money in an SME if you don't have a prospectus, right? Because this is what's happening. They don't have a prospectus. What then has created problems for all of us and at the same time facilitated financing for small SMEs is platforms came into the picture, right? And platforms are not SMEs. Platforms are usually run by finance people, quite sophisticated. They set up these things with the help of some technology people, right? And they get SMEs to use their platforms on the one side, and then they get investors to use the platform on the other side, right? So they actually raise a lot of money, sorry, not many, but money from many investors for many different companies. They serve as an intermediary, a new kind of intermediary, right? But they have managed to avoid regulation to a large extent because they managed to ride on this idea that we need to help SMEs. And then they said that, well, they're raising money from SMEs, but actually they have become a risk to many people, right? Because they've actually become intermediaries, which have kept a lot of money within themselves because they now allocate the money that they raise from many investors for many different companies, and how they allocate it and what they do with it becomes a problem, right? So they have formed the biggest challenge in corporate and securities laws today. They appeared to be helping SMEs, right? Regulators wanted to help SMEs, but as it turned out, many of these platforms, I said, were people who are finance and technology people who actually wanted to make a lot of money for themselves. And they serve as intermediaries with a lot of risk in them as they trade the coins and the tokens and even the shares of these SMEs. And they manage them, but they also provide financing, right? And they provide financing for all sorts of digital assets, but they are very lightly regulated. So the regulators all around the world now are trying to come up with new forms of platform regulation. The problem and the reason why they have managed to escape regulation is that the regulators know how to regulate big stock exchanges like the Jakarta Stock Exchange or the Singapore Stock Exchange or the Korean Stock Exchange. But these intermediaries they didn't see themselves as exchanges, and they convinced many people they were not exchanges and that they were platforms. But actually they are exchanges, right? And they are exchanges that allow a lot of financial instruments to be traded. They are held, these intermediaries hold these financial instruments as well for their customers. And they also finance the trading of these things, right? But the relationships that you have as an investor on these platforms isn't clear, right? What sort of interest do you have in those financial instruments that they hold, right? So I give you some examples of the things that they have done, and that's why some of these platforms have become very wealthy, because the relationships with the investors are not clear. They trade digital currency like Bitcoin. They traded Terra Luna, but then we have seen Terra Luna, which was a coin, fail, right? They also manage assets, as I said, crypto assets. But they've also failed, like the Three Arrows funds. There was managing up to $3 billion worth of crypto assets when they only actually licensed to manage 250 million, right? What sort of interest do you have in those assets that the fund had, right? You may think you are a customer and that you had, say, Bitcoin in the Three Arrows fund, right? But when the Three Arrows fund goes insolvent or is liquidated, what sort of interest do you have? Do you think that you have the Bitcoin that they're holding? Or does the Bitcoin actually belong to the Three Arrows fund, right? This is what investors are now finding out, that it's very likely that the Three Arrows fund, in fact, owned the Bitcoin that you thought you had with them, and that all you had was a relationship with the Three Arrows fund where you are a creditor, right? And when they're insolvent, you end up having to claim as an unsecured creditor in the winding up of Three Arrows fund. Yeah, there's a comment from Nguyen from Vietnam, right? Luna is a crypto disaster, for sure, right? It was supposed to be a stable coin pegged to the US dollar, but in the end, how would you know whether the people who created will in fact peg it to the US dollar? Will they in fact buy $1 US for one stable coin, right? They might just use the money for their own purposes, right? And that's, I suspect, what happened. So the platforms are a serious problem for us. The worst platform was probably FTX, where many Singaporeans traded. I think not that many Indonesians used the platform. There were 200,000 Singaporeans every month who used FTX. FTX, in fact, created their own coin and token as well, right? So they created their own assets, right? And they treated it as if it was a real asset to cover all its trading losses in a subsidiary until everything collapsed. And now, again, people are not sure what sort of relationship you have with FTX if you are a customer of FTX. Very likely, you will be at best an unsecured creditor, even though you thought you own all sorts of crypto that FTX was holding for you as a custodian or as a platform. Yeah. So if I could give you any advice, one thing you should look out for whenever you look at a business is that you have to be very careful of a business that has an ability to treat things that it creates, intangible things. I'm not talking about creating and building things like many people in Indonesia do, right? Where you say you manufacture a motorcycle or a washing machine, right? Those companies are creating real things. I'm talking about the things that a company creates, like its own shares, its own coins, right? And they treat this as an asset because they think that it has got some value to it, right? Now, a share has value when a shareholder buys it, but that shareholder must be somebody unconnected to the company. What we're seeing a lot of in the US, especially with things like FTX, and even before that with Enron, was a company that treats its own shares as an asset by issuing it to a related party, right? And that related party gives it a bond. So the company gives its share to a related party. The related party buys the share in a way, but in return provides a bond. And then both sides starts thinking that now they have assets, right? But these shares and these bonds have not reached the hands of the public yet. So you can't treat that as a real asset. But they do that, and unfortunately, that's how things start getting problematic. And this is what FTX did when they issued their own coin to Alameda Research, which was run by a lady who was close to Sam Bankman-Fried. And they started treating it as an asset, right? And used that FTX coin to go to the bank to get loans based on that. And so now you're put into circulation something that was never really properly bought by an independent third party as an asset. So the story here is that we want to help SMEs by reducing regulation for initial fundraising so that no prospectus disclosure is required. And I think every regulator in the world wants to do this. And I think there's nothing wrong with that. But that should not allow platforms to trade financial instruments without regulation. So just because we allow an SME to issue its coins or its tokens or even its shares without prospectus disclosure doesn't mean that we should allow those financial instruments onto a platform that's been set up by finance/technology people without regulation, right? The problem right now is that we only seem to regulate securities exchanges like the Jakarta Stock Exchange because we think that only if it's a security like a share or bond, right, that's been sold to the public, should we then regulate it. But I think we need to divorce and separate what we see on what we call the primary markets, the IPO markets and the ICO markets, and we have to separate that from the secondary markets, which is the trading aspects of things, right? So platforms should be regulated regardless of what sort of financial instrument is traded, right? So one way to do this is to say that when it comes to prospectuses and the prospectus requirements on the primary market, only shares and bonds may be considered securities. But when it comes to the secondary market and trading, coins and tokens should also be considered securities for the purposes of platform regulation, right? What do we have to do? Well, we have to ensure that these platforms provide fair trading. We have to regulate the way they provide financing. We have to improve disclosure. We have to prevent market manipulation of these financial instruments. We have to control the fees that these platforms charge. And we have to ensure system continuity so that they cannot use the excuse that the platform goes down and something has happened and your coins have disappeared, right? I think the problem arises more with common law countries than with civil law countries, because civil law countries have not been so quick to see coins or tokens or non-fungible tokens or NFTs as property, whereas the common law has been very quick to see these things as property, right? In the common law, so long as there's some value to something, we'll say it's property. But I think in civil law countries, you are less willing to say it's property. But the danger with the courts in Singapore and in England and in New Zealand saying that all these coins, tokens, NFTs property is that allows bad people to go around and market these things as if they were real assets, right? Regardless of whether it is actually in fact backed by anything. So I just want to point out to you about how there is this danger of how capital is now being coded in a way which can mislead us and may cheat us, right? Katharina Pistor is a very famous Columbia law professor, and she wrote this book, I think, 4 years ago now. She argues that the law selectively codes certain assets, right? Endowing them with the capacity to protect and produce private wealth. And she was talking last year about the common law. With the right legal coding, using the best bankers, finance people, lawyers, and now technology people, any object, claim, or idea can be turned into capital. And importantly, for those of us today, lawyers are the keepers of the code. We know how to use the law to create what looks like property. Right? Pistor describes how they pick and choose among different legal systems and legal devices for the ones that best serve their clients' needs, and how techniques that were first perfected centuries ago to code land holdings as capital are being used today to code stocks, bonds, ideas, and even expectations, right? Assets that exist only in law and not physical assets that exist in reality. So as I said, you've got to be very careful. In Indonesia, much of your business is still about making things. That may not be so true in the West, where a lot of the so-called assets are intangible assets, and they start being traded, and people start believing, like with Luna, that it is real, right? And then suddenly you decide when no one wants it, it's got absolutely no value at all. So it's an interesting book because she describes how from the start in Indian land or unclaimed land in America was claimed by some settlers simply by knocking some stakes into the ground, and for there, they used the law to say that that became their property, even though it had been used by the Indians for many, many years. And similarly today, if you look at NFTs, non-fungible tokens, I'm quite sure that that word non-fungible tokens has been created by certain lawyers who knows that fungibility is an issue with property. In other words, if something is fungible and cannot be specifically identified, because fungible just means that it's the same and no different from other things, that cannot be property. And that's why they call it a non-fungible token. In any case, platform regulation is not just about the trading of financial instruments, but I think we also need to think more about platform regulation because businesses may not be structured as companies again as often in the future, right? There's an important article by three very good academics that we know quite well, Mark Fenwick, Joseph McCaffrey, and Eric Vermeulen. They wrote this again 4 years ago, that we have been too worried about corporate governance when it's really platform governance that we have to worry about. And this was published in the 2019 European Business Organization Law Review. Again, this goes back to the story that I said earlier, that company law should not be a series of mandatory rules, but maybe a form of contractual rules that allows flexibility, because it might just be that businesses will not be using the corporate form if it's too strict. Rather, they will go back to loose contractual alliance using technology so that you do not have to form a company with shareholders, directors, employees, right? You can outsource everything, right? You can outsource not just things that you don't do, but even you don't even have permanent employees anymore, right? If you need to do anything, you do it just in time. So you have certain people that you use subcontract. If you need to make certain decisions, you have other people that you subcontract it to, right? And you don't have shareholders because you don't want to have permanent capital that has been contributed and you have to worry about these people. That's why coins and tokens was a good idea, right? But we need to then make sure that all of this can still be run and governed properly, right? So your basic enterprise can be a partnership, it can be a foundation, it can be a trust, so something that we use in Singapore. I don't think you have that in Indonesia, so I guess the partnership or foundation may be more important. Where you contract to give some non-equity interest to investors, right? So like coins and tokens can be given to investors. It makes its decisions using AI, so you may not need to have a business using directors anymore. And you outsource all your work to independent contractors, right? So let me just give you a diagram, which is from their article. So you've got a platform in the middle here, right? You've got your investors possibly with which uses coins and tokens, and they have some kind of interest in the platform, but it's not a share or bond, right? And the company, the business doesn't do R&D anymore because traditional businesses would have research R&D that's very costly. Here, they have an institution that they outsource it to, right? Who does the platform work with? Well, they work with consumers, but consumers have never really been part of the company anyway. They are third parties that deal with the company, right? But employees and flex workers, a lot of employees used to have contracts of employment with the company. You don't need that anymore. You outsource it, right? People develop things. So this is more for, in a sense, other technology type platforms, right? You have developers there who do things for you. You might deal with other companies, but you yourself are not a company, right? And also you deal with governments now because governments may require certain kinds of cybersecurity things to be built into your platform and so on, right? So their story is that a company like Philips today, which I still think the name is used quite a bit in Indonesian, people buy things with the Philips brand. But the reality is that Philips doesn't actually make things anymore. They are really like a platform, and the things are made by a lot of other people. They come up with ideas, right? So you can argue that Philips is like a smart platform with a strong research component here, and investors, shareholders still in Philips, but everything else they have outsourced. So platform regulation, I think, is the focus for the future. And this ties into the fact that since platforms can be partnerships, it can be contractual arrangements, we need to keep the partnership and other business laws relevant, right? And again, we have to let them be as flexible as possible in its internal structure. The biggest danger is to make partnership law very inflexible. The problem, if we make it too flexible, is that what it means to third parties from an external perspective becomes very difficult, right? So in Singapore, for example, we not just have the general partnership where all partners are liable, but we have the limited partnership and the limited liability partnership. For those of you in Indonesia, if you don't have these structures, you may not be so confident dealing with the LP or LLP in Singapore, right? And so because of that, again, we need to improve disclosure so that third parties, people like yourselves from Indonesia, can find out more about the internal arrangements and to see which partners don't have unlimited liability and which partners have limited liability, right? So it is not so perfect still, disclosure, because in this world, there are certain things that are hard to find out. So you still need some mandatory rules, right? But we don't need that many mandatory rules. The few mandatory rules that we require, one of those was the one that we looked at earlier with Sequana. You cannot transfer your business assets with intent to defraud creditors, even outside of insolvency. I think this is one of the few mandatory rules that should apply not just to companies, not just to partnerships, but even to individual sole proprietors, right? Because otherwise, creditors will not lend money to you going forward, and it'll become very costly. Lending will become very costly going forward. I'll quickly finish up with the most high-tech things like artificial intelligence. With artificial intelligence, one day this could replace human directors on corporate boards, as well as senior managers making day-to-day decisions, right? I'm not saying I truly believe this because AI has problems of its own, but it is a possibility that this can happen, right? That algorithms could make all the decisions for the companies, right? Certain companies obviously still need to have human discretion, but other kinds of companies could run just by having automatic decisions made by algorithms. The good thing about this is that once you don't have humans, there are no agency costs, right? You don't have to trust the human being, the things that we talked about earlier with agency and having to trust human beings, and that being a cost. So you will not have conflicts of interest, nor will they be lazy, right? These are the agency costs. The only dangers now you have to worry about is that they have the characteristics put in by the programmer, right? And the programmer could be a bit strange. If the programmer is fraudulent, there might be problems. But assuming the programmer is not fraudulent, then it's a question of just mistakes that are made by the programmer. So you have to think about this, right? If the mistakes happen because the AI, for example, is a factory that's run by robots, right? Unfortunately, that robot kills somebody on the work floor. Who is responsible, right? At the moment, Singapore cases are saying that it is what the programmer did at the point of programming, right, that makes him or her responsible. So the programmer is only responsible up to the point of programming. And even if things change later, or there's some kind of machine self-learning, the programmer will not be responsible, right? So I think it's a pragmatic solution, but I think it's something that we have to think more about, right? Because if there's machine self-learning and you say that the new things that have been learned is not the responsibility of the programmer, then theoretically nobody could be responsible for this, right? And so if somebody is killed on the shop floor because the machine learned something that it was not programmed to do, and because of that, it actually did something that it was not programmed to do initially, who's going to be responsible for that, right? In any case, governments should be careful with AI, as many people are now saying that it could destroy jobs, and that maybe we should actually sometimes be a bit less efficient and have more human beings on the shop floor rather than just robots, right? But unfortunately, because of competition between countries and between companies, more and more of them want to reduce the human element because not only is it costly, there's also the difficulty of doing with human relationships and so on. But I think governments should be more enlightened and careful with AI. What about decentralized autonomous organizations, right? These are businesses that one day becomes completely self-operating, self-sustaining, and self-governing. That's the dream of the technology and finance people, because they just want profits created and they don't want any humans involved. So people talk about the use of blockchain, smart contracts, right? However, I've got a colleague here who's quite well-known called Kelvin Low. If any of you are interested in finding articles which are critical of the blockchain, for example, and smart contracts and tokenization, he's very much on social media. I'm not at all. I think he has got either, it's not even Facebook anymore, I think it's Instagram or Twitter. So you can see what he writes, right? He says that these promise more than deliver. So Ethereum, which came to Singapore about 5 years ago and said that they were completely secure, has been hacked, right? And then after that, you need to take a fork because you need to sort of do a separation, and that still needs human decision-making. So all this talk about not requiring humans in the end may not absolutely remove the need for human decision-making. It is true that for certain kinds of businesses, you might not need too many humans involved. So for example, if your business is just an investment fund, right, which only business is trading in financial products, and it's not like an Indonesian company that manufactures things in the industry or the world of industry, then of course it is easy to use blockchain and smart contracts because it's just algorithms making investment decisions and buying and selling shares and so on. It doesn't actually need to make anything, right? And this is true. Much of the blockchain technology has been used for the right side of the balance sheet and not the left. Remember, I tried to show you the balance sheet. Unfortunately, I forgot to bring one anyway. The screen's a bit small. The left side of the balance sheet is usually what you see, the asset side, right? The businesses, the cash, and all that. The right side of the balance sheet is just the side where you have your share capital, your liabilities, and then at the end of it, your net shareholders funds and so on, right? I think blockchain technology is great for capital, managing share transfers and so on, right? And it may also be useful if you're an investment company where even your left side of your balance sheet, your asset side, are just shares and bonds of other companies. That's fine, right? But it's not going to be that useful for companies in Indonesia that still makes things, right? Whereas in the West, it is possible because they take things. And this is from another famous female academic, Mariana Mazzucato. She's from UCL, and she wrote this book in 2018. In this thought-provoking book, she argues that it is far too easy for those operating in the market economy to get rich by extracting value from those who actually create it, not by adding it themselves, right? We need to return to the question, what creates value? So the argument that she would make is that in Indonesia, much of your economy is still about making things with true value, that in the West, some of them are just funds and some of them are just trading entities, and they actually they actually get rich by extracting value for those who actually make it. So my conclusion, and I give this with not much confidence, and even if I don't sound very humble, I am trying to say that it is not something I'm sure is going to happen, because who can predict the future? That Indonesia should continue to focus on the real economy, not finance. Carry on with your SMEs, not your large industrial manufacturing companies. I've not been to Surakarta, but I've been to Yogyakarta. I still see a lot of small businesses everywhere, farms and so on. That, I think, provides most of the jobs that are still needed in the world, right? Where your laws are concerned, have some core mandatory rules to give confidence to third parties. So your Companies Act, even your partnership laws, should have some more mandatory rules if you feel that you have to, right? Because it's very difficult to create too much flexibility. But where you can, maintain some flexibility. So in your corporate laws, your partnership laws, foundation and trust laws, so that you can change with the times without having to go back and change those laws, right? What I'm saying here is that you future-proof your regulation by making them technologically neutral. You draft your laws in such a way that you don't have to keep amending them just because the technology changes. So your drafts people in law, right? And someday, some of you, after you graduate, will be drafting laws, make them neutral from a technological perspective. At the same time, however, if we want to have flexible laws, we must improve disclosure. We must make it easier for people to access what the terms of and the internal arrangements in the companies and the businesses you have are, right? So that they will trust these businesses and they will deal with them. Finally, do not believe too much in coins or digital assets or arguments that recognizing more property rights will make society immediately wealthier, right? So this is the argument that some of you would have heard before. And it was an argument that I believed once because I was also a property law academic for a time. I teach trust law still, right? And this was from Hernando de Soto, who said that so long as we have better land registers and property registers, third world countries will become richer much quicker, right? This is just an argument that somebody who wants to create more registers and who are pushing a certain agenda will make, right? Because property doesn't come out of thin air, right? Most property are still things that are actually made by people, right? So carry on doing what you're doing. And I think, you know, this whole get rich quick situation that we have seen in the last 5 years with technology, coins, tokens, NFTs, I think is coming to an end, right? But who knows? I may be wrong, and that's why I'm an academic and not in town practicing law. Sorry, I didn't leave you enough time. Arief, is 2 minutes, or are there any questions? I tried to answer some questions that were in the chat, but I'm not sure anyone has any questions. Do you have a question, Arief?
Okay, thank you, Prof. Tjio. Your presentation is excellent, very excellent. And I think member of the short course will be enthusiasm with the ask and question about your thema, about your presentation. This is much more sophisticated, yes, sophisticated methods. It just means high risk. It is like a gambling, yeah. I see from your presentation this high risk and high return. It is was like a gambling. So for the most people, except for the very skilled player, I think for most people it is good to saving their wealth in the property or maybe in the gold, which is have materials and reals rather than saving in the coin with the uncertainty value without any coherence and with a high risk of scamming or maybe something's unreal, because it is like gambling, what I see from your presentation. There is one.
Shall I try and answer that? I think
Yes.
you're right. But the truth is that human beings will always gamble. And so I think we can allow it, but we need to regulate the platforms. So even if you think it's gambling, it should be regulated, right? And the other thing is that the other thing is I am okay with SMEs raising money without much disclosure, because even if that is risky, it does help the underlying small business. What I think is really bad is that the platforms are not small businesses. The platforms are run by sophisticated people, and they are trying to attract others into
people.
this? Yeah.
There is three answers.
Okay,
Three
I'll try and answer those questions as fast as I can, because these are not, the first question is by Kevin Arnold. Can people see the chat? I'll just, so I can't fully answer the questions, because about things like what's the personality of a robot and so on. So firstly, legal personality, the law, we say that let's not be too hung up about legal personality, because in Singapore, even the trust, the partnership may have some kind of legal personality, right? So it is possible for some of these digital things to have legal personality, but we have to be careful not to see even a corporation which has legal personality as a true person, because they're just artificial entities, right? So I would say that the best way to approach it is to give it some form of legal personality, but understand that it's only artificial, right? Who should be responsible if things go wrong with administrators? As I said, in Singapore right now, I think that the person who writes a program is responsible up to the time the program is done. After that, I think the person who benefits from the system should be the one responsible, right? So if, for example, the business has used a program that somebody else wrote, but now the program has changed, then the person who is running the business now should be responsible. Yeah, I can't really answer the last questions on cybersecurity, because you talk about international investments that adopt artificial intelligence and national security. I know there's a concern everywhere, but my own sense is that that is not a company law matter. It's a political question, right? Because there's all sorts of things going on between the US and China. They don't trust each other. And so everybody seems to think that they are getting data from each other, but I'm not sure from a business perspective, and even from a personal perspective, to me, data protection isn't that important. I'm not that concerned about data protection, right? I'm more concerned from a corporate law and securities angle about the manipulation and the cheating, right, that Arief was talking about. Yeah, well, I'm not a technology lawyer. This is the next question about AI from Kim. What I've told you is what I've seen in company law so far, that we are seeing that AI has a part to play, but I'm not sure at the moment that what it actually means, because for vast majority of businesses, you still need human intervention, right? And those people who claim that AI can do this or do that are probably trying to sell something, right? And claiming more than it actually is. And this is a problem that I find going on now, and I'm not sure, therefore, what to trust. That every few months, they're coming up with something new to keep the technology story going on. So from about 5 years ago, it was Bitcoin. Then it became tokens and coins. Then all this talk about Ethereum. Then there was also this talk about the metaverse, then tokenization. Now it's AI. So they're just keeping this technology story going. And I think that going back to what Katharina Pistos said, there are many people out there now whose jobs are simply to create expectations and to try and monetize those expectations instead of actually building anything. The actual building of things is still going to be very, very difficult, right? And the best example or the worst example of this is the metaverse. Up to about 6 months ago, everyone thought the metaverse was going to be the next great thing. And today, people are saying it's failed. And all this within 6 months. So I'm not sure that any of this is really going to change the world. If you're talking about robot technology, that's always been around. The cars have been made by those things. If AI can do more and take over decisions totally, well, if that really happens, in fact, most of us will be out of a job, right? Is that okay, Arief?
Okay, thank you for your presentation, Professor Johannes. I think it's very excellent presentation. It is making us or make have us have a new view about digital age and its transactions. Prof. Tjio, in the maybe in the next years, I hope our your presentation you will be presentation again in the our short course because it is course initiated for the international class. There is very excellent of your presentations. And I'm on the sides of the Faculty of Law Universitas Muhammadiyah. Thank you so much for your contributions. I hope it will be opening new knowledge for us, opening for us a good path for knowledge of this about these terms, about these materials, and this is was very valuable information from you. Thank you so much. Greetings from Universitas Muhammadiyah Surakarta.
Okay, thanks a lot. Take care, everyone.
Okay, thank you so much, Moderator. We close our shortcast, international shortcast. Hope we meet. I hope we can meet again in the next years with different views.
See you.
Thank you so much. Greetings for all of you. Thank you, Prof. Tjio. Questions.